Kenneth Overwater, said prosecuting attorney for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ahmed, who approaches.
This case opens in uncertainty, and that's never a good sign for a defendant. Right out of the gate, we're told the defense attorney hasn't even been able to speak to her own client. He's back in jail, possibly facing new charges, and the court is already hearing whispers about competency. That alone raises serious red flags. Competency isn't a routine box to check. It means the court is questioning whether this man even understands what's happening to him or can properly participate in his own defense. And notice how this unfolds. The defense is relying on secondhand information from colleagues. No direct conversation, no clarity, just fragments. That's a dangerous place to be in a courtroom because judges operate on facts, not fog. When a lawyer can't confidently explain their client's situation, the court starts filling in the blanks, and those blanks rarely favor the defendant. This moment sets the tone for everything that follows. We're about to watch how Judge Simpson balances legal procedure against real-world chaos, a defendant with instability, possible violations, and a system that demands structure. The question is simple but heavy. When someone's life is clearly off the rails, does the court lean toward protection or control? And at what point does compassion give way to enforcement?
Yeah.
Your name?
Can you say
Ahmed? Yeah.
And Your Honor, I did learn yesterday that he'd been back in jail. He was supposed to be arraigned. I believe that he'll be arraigned on 15th District Court matter. So I wasn't able to speak with him with regard to this case. However, in my conversations with one of my colleagues, I was advised that competency would probably be in our best interest at this time. So I did submit one to the court yesterday.
All right. I guess I'm a bit concerned because of what we never got the report though.
That is correct. That's all right.
Are you clear as to why he's back in jail or no?
I have a pretty good understanding, Your Honor.
Okay, because so that you're aware, all we received was a violation of conditional release face sheet, our previous order, and then it just said that the defendant was committing arson.
Your Honor, and my understanding after review of that warrant, and I'm sure the prosecution can correct me if I'm wrong here, is that is not going to be an arson charge. That's going to be a disorderly person or disturbing the peace.
Got it.
So that'll be.
I'm just telling you what the sheet.
Yeah, thank you.
All right.
I was made aware of that.
Oh. What I will do.
That's me, and
is,
I'm going to go back and talk to you. Okay.
Given the statement of counsel, a forensic evaluation will be ordered. I've signed the order regarding competency examination. I'll set a competency date for February 19th, 2026, 9 a.m.
This is a pivotal legal turn. By ordering a forensic competency evaluation, Judge Simpson is effectively pressing pause on the normal flow of the case. In plain terms, the court is saying, before we go any further, we need to know whether this defendant is mentally capable of understanding the charges and assisting in his own defense. Without that, the entire process becomes unconstitutional. But here's the tension. While the case pauses, the consequences do not. The defendant is still in custody. His freedom is still on the line. And now, bond enters the conversation. The judge openly wrestles with whether to leave it as a personal recognizance bond or impose cash. That's not procedural. It's philosophical. It's the court asking, can we trust this person? The defendant speaks up, claiming he has no money, staying at a shelter, determined to fight the charges. That's raw vulnerability colliding with judicial reality. Judges aren't just referees, they're risk managers. When someone has recent jail contact and possible violations, trust erodes quickly. What would you do here? Would you keep the bond low out of fairness or raise it to protect the public? This is where law meets human consequence, and someone always pays the price.
His bond in, I don't know if you want me to change it or not at this point, or just leave it a PR. Says he's not getting any credit on this.
I understand, Your Honor. I would ask for a very nominal cash bond on that, just in case.
Your Honor, just to reiterate, I don't have any money right now. I got $550 credit. I'm staying at the Lannis shelter. Well, I plead not guilty to all the charges. I plan to take this all the way to trial.
And that would be part of my client's bond argument, I imagine, Your Honor. He would be asking for a PR.
Well, I think given the circumstances, I mean, I'm not sure what went on during the other thing, but it looks like it might be a violation. I will set his bond. I'm going to adjust his bond. I'll set it at $2,500. I'll give it 10% privilege on that.
That number may sound small to some, but for someone living in a shelter, it's a wall. A $2,500 bond with 10% privilege still means $250 cash just to walk out the door. For defendants living paycheck to paycheck or with no paycheck at all, that might as well be a locked gate. Judge Simpson's language is careful. He acknowledges uncertainty about what happened in the other case, yet he still adjusts the bond. This isn't punishment, it's risk control. The court is signaling, something about this pattern concerns me, and that's the heartbeat of bond decisions. They're not about guilt, they're about trust. The defendant says he'll take this all the way to trial. That's resolve, but resolve doesn't override a violation history. In the court's eyes, intent doesn't erase behavior, and this moment teaches something critical. Bond is not a right. It's a privilege weighed against past actions.
And then certainly if the circumstances deem it appropriate, you can raise it before the court.
Thank you, Your Honor.
Thank you.
Your bond is at
Thank you.
It's really nominal.
Court calls the case. Keep moving. Court calls the case.
Your Honor, if we could be heard on bond.
Yes.
Mr. Campbell was remanded, I believe 2 weeks ago today for a positive THC test. He does have a place to live. He is currently, he does have I believe a nominal bond in a 15th district case. He lives local, just at the far east side of in Belleville. We'd ask the court to release him. He is employed. We'd ask the court to release him, allow him to test and demonstrate to the court that he's not going to use any substances.
Ron, to the people at all.
Your Honor, this is an operating while intoxicated second offense was put to action with under 16. I'm concerned about him being out at all. He couldn't comply on bond in the first place. I'll leave it in the court's discretion, of course, but I'm concerned that if he is released, a bond as he was before.
Your Honor, this is a 25 matter. I believe there was the date of incident was alleged to have been in 2023. He is he was in, I guess is technically still a participant in the 15th district sobriety court. I'm not going to gild the lily. I mean, I think that's he's got a violation there, and that's certainly in jeopardy. He was scheduled to be seen by Dawn Farms near the time he was remanded. I don't know if that what the circumstances are in that regard at this point.
Motion for bond reduction is denied. Bond will continue. Thank you.
Here we see Judge Simpson draw a hard line. This defendant tested positive for THC in an operating intoxicated case, already a second offense. The court isn't just reacting to one misstep, it's responding to a pattern. When someone fails conditions once, the system becomes less forgiving the second time. The defense presents stability, housing, employment, willingness to test, but the prosecution frames risk. He couldn't comply in the first place. And that single sentence carries enormous weight. Courts are built on predictability. If a defendant already failed under supervision, every future promise sounds weaker. This isn't moral judgment, it's statistical thinking. Judges are trained to minimize harm before it happens. Releasing someone who already violated conditions becomes a gamble with public safety. Would you take that gamble? That's the silent question in every bond hearing. The court doesn't get applause for restraint, only blame if something goes wrong. And that reality shapes every denied you hear.
Thank you.
Thank you, Your Honor.
Court does call the case. People versus Ralph Wilson.
Ralph Wilson, Your Honor.
Yes.
Trevor Mayville.
Stephanie Cannon on behalf of Mr. Wilson. Mr. Wilson, could you please state your name for the record?
Ralph Wilson. What will we do?
Your Honor, we are asking for a brief adjournment in this matter. for see if we can get any negotiations going. In addition to that, because of how his phones accepts incoming calls, we were not able to act yesterday. So the first time I've had the opportunity to speak with him is, or not yesterday, Tuesday. The first time I've had the opportunity to speak with him is today.
All right. Before I give you your date, there's a violation report. Have you seen it?
No, Your Honor, may I approach?
It's a SCRAM tamper.
May I approach?
This is where the case pivots from routine to reactive. A violation report instantly changes the courtroom temperature. It means the court believes something went wrong while the defendant was under supervision. And in this instance, the issue is a SCRAM device, a monitor designed to detect alcohol use through the skin. These devices are unforgiving. They log data continuously. They don't care about intent. They care about readings. So when a report says tamper and alcohol detected, the court's starting position is skepticism. The defense isn't denying contact, they're explaining it. Work chemicals, hand sanitizer, discomfort, tissue, Vaseline, that's a human explanation colliding with machine logic. Technology doesn't understand pain. It doesn't understand jobs. It only records anomalies. Judge Simpson's tone matters here. I'm not believing anything he's telling me. That's not cruelty, it's caution. When someone is already under alcohol monitoring, every explanation is filtered through history.
Take that music. And can you get me another one? Yes.
I made me to. Oh, I don't know.
So, Your Honor, in speaking with my client, he has indicated he is not drinking. He has not been drinking. The only thing he can think is happening is that his job and what do you do for a living?
Custodian. I'm on diabetic. I mean, I'm on disability, but I work for First United Methodist Church downtown Ipsy behind the transit. And I work with a whole lot of chemical. I mean, I wash my hand, but I do use hand sanitizer. So when I got the ankle bracelet on November the 10th, the lady put it on, but she put it on this one on my right leg too tight. So when I got out the next day, I went over there and they took it off on my right leg and put it on here, but it's on my bone. And so the only thing I did, no one tell me anything. So I just took a piece of tissue and tried to put down there, keep it off my bone.
And so he did go in, Your Honor. He had it adjusted because of this comfort he was having. So they have subsequently loosened it for him. They did
go into what day?
So
It had to be I went on the 10th, so probably the 14th or the 16th. And that's when I asked the officer over
At what
there.
time did you do that?
I went over there. That's when I paid. I think I paid like 20 something. Yeah, $20. That's when one officer, he took it off my right foot and put it on my left. And I told him, I explained to him, I told him, I said, yeah, it was on my bone. And I took some tissue and put down the triangle because it was swollen. He took it off and he put some of that thing on there and, charged it back up. And then prior to that.
Does he want a hearing on this? Because I'm not believing anything he's telling me.
want a hearing on the fact that you. Yes, Your Honor, my client would be asking for a hearing. He's saying he's not used alcohol. The only thing he has done is use some things that he has to use for his job, which he can bring in to show the court. So yes, he's asking for.
What kinds of chemicals is he talking about?
I mean, I use soap, pine soap, stuff to clean the toilet with. I mean, but I haven't drunk nothing. I even told the man over there that I sign my own self up at the church every Thursday at 7 o'clock to go to AA. So I haven't drunk nothing. How much did?
It doesn't even make any sense.
Yeah.
Your Honor, can he take an ETG test?
Well, at some point he might be able to, but right now, I'm a bit concerned with what he's telling me, that there's somehow or another a chemical that's doing that. And if that's the case, we would have readings all over the place because it would work more than just one day, right?
This is judicial reasoning in action. Judge Simpson isn't dismissing the chemical explanation emotionally. He's dismantling it logically. If hand sanitizer or cleaning agents were the cause, the spikes wouldn't be isolated. They'd be everywhere. Patterns matter. Courts don't just look at what happened, they look at how it happened. And this is where defendants often lose ground. Even truthful explanations can sound improbable when filtered through data trends. The judge is saying coincidences don't repeat themselves this neatly. The defense tries to anchor the defendant in routine, workdays, AA meetings, self-improvement. That matters, but it doesn't erase the device logs. The court must decide whether the explanation is plausible enough to justify freedom while waiting for a hearing. Would you believe him? Or would you see this as convenient timing? This is the gray zone where justice lives, between trust and proof.
And Your Honor, I don't have what the readings are. I know that what this report is saying is that on November 16th and on November 14th, were those days?
Yeah.
Okay, so he can tell you that he was at work on those days. None of these other days has he tested positive for anything on because he's not doing anything.
And those are two days
That they're a tamper.
So he's going to acknowledge he put something in between that and his skin because of the discomfort.
I told them that.
He did admit that.
Yeah.
He just was doing it to put a cushion though, because it was digging into his skin. And again, they have subsequent, and there was a bruise, which is why they moved it from the one leg to the other leg. And so it has been adjusted. So he's not in quite the discomfort that he was in.
Why was he talking about an alcohol reading?
I'm sorry, why was he telling you?
Why was he telling them about an alcohol reading?
No, he did not. Apparently they told him that there was alcohol detected, and he said the only thing he can think of, it's the chemicals that he's working with because he's not been drinking.
And I bathed with a native soap. I mean, the lady that put it on, she told me, go on Amazon and get, order something with no soap.
No alcohol.
And no alcohol. And the native, it don't have alcohol in it. And that's all I use. Besides the toothpaste that I run on the 10th of November out home. That's what I use to brush my teeth with. Now that got alcohol in it. I got that at home. That's what I use. Yeah, like I said,
well, when I'm looking closely, I don't see an alcohol reading.
And I was going to say, Your Honor, I can't see any of it.
Which is why I'm trying to figure out why were they discussing and why was he stating that the alcohol reading came from chemicals?
He is telling them that because he's saying I didn't drink. The only thing I can think is because of the job that I do. So when they asked him about it, he's like, I haven't been drinking. Only thing I can possibly think is because of the chemicals I'm around at my job.
Your Honor, I agree that there's no alcohol reading, but the violation describes that on both of the separate tamper events that alcohol was detected.
Correct.
Which would
during the tamper.
Which would work.
If you look at the bottom first page, the last bullet point
First page.
doesn't give a reading, but it indicates that alcohol detected during the tamper.
That's normally they distinguish between a consumption event and detection of alcohol, correct? Like we can't tell just based off of this, but when you combine the detection of alcohol with the verified tampers.
Yeah.
And again, Your Honor, it would make sense then, because if he does have something on his hand, but he's trying to adjust the ankle thing, it would detect because of whatever's on his hand.
Now my wife dropped me off. Now I did get me a Wendy's burger, and I did use the hand sanitizer in the car to wipe on my hand. So I mean, no.
So on two separate occasions, this happens? Really?
No, when I went to pay,
It's not- come on, you're okay.
no,
You're
no.
okay. Your Honor, my client, he is working on his drinking issue.
Yes.
He is saying that during this time frame, the only time he has ever adjusted this was because of the pain. Subsequently, he's gone and gotten that fixed. It's my understanding that there's been nothing since he's gotten it fixed, because it's been addressed. And the only thing he can think of is that whatever chemical he has is on his hand when he was adjusting and trying to get some comfort or some relief from the issue is what was detected.
I explained to them, I used a tissue and I put some, it was a bruise over here, and I put some Vaseline on there. I mean, if they got alcohol in it, I mean, I don't know, but I haven't had a drink. I signed myself up at my job every Thursday night from 7 to 9 AA. No. And the guy over there, the last one on the 16th, he told me I can use any kind of soap. So he's telling me this, then the other one tell me no. So then the other lady tell me something else.
What did I tell you?
Yeah, I
Okay.
mean, yeah.
Anything else?
No, Your Honor, just.
I'll give him a hearing on the second half of the violation. He admits to the tampering, but as to the alcohol detection on it, I'll set that for November 25th, 2025 at 3 p.m.
This is procedural fairness at work. Judge Simpson acknowledges the defendant admits to tampering, but separates that from alcohol consumption. That distinction matters legally. Tampering is one violation. Drinking is another, often more serious one. By granting a hearing, the court is saying, you get your chance to prove this wasn't alcohol use. But the bond remains. Freedom is paused while truth is tested. This is how due process actually looks. Not cinematic, not emotional, structured, deliberate, slow. The court doesn't explode, it schedules. And for defendants, that wait can feel like punishment before proof. But from the bench's perspective, it's containment. It's preventing potential harm while facts are sorted. Is that justice or precaution? In the courtroom, those two ideas often overlap.
I'll adjourn his probable cause hearing to that date. That's 5 days out from now. But at this time, defendant's bond is revoked. Defendant's remain.
This case shows the quiet power of procedure. No shouting, no theatrics, just a series of decisions that determine whether someone sleeps in a cell or in their own bed. We saw Judge Simpson confront uncertainty, mental competency, prior violations, and technology-driven evidence. Each ruling followed a pattern. Pause when capacity is in doubt, tighten control when trust is broken, and allow hearings when claims deserve examination. This isn't about guilt, it's about structure. Courts exist to manage risk before it becomes tragedy. Every bond decision weighs liberty against safety. Every violation erodes credibility, and every explanation must compete with data. The system isn't emotional, but it isn't heartless either. It grants hearings, it listens, but it never forgets patterns. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.